What I want to make a presentation on is this entire concept of religious minorities and how has the Indian Constitution treated them, and sort of map out the way and the road, the broad path which the Indian Constitution has followed in treating religious minorities till where we are today. I've used the term constitutional avatars. It's because I'll explain that as I go through my presentation. It's been a deliberate use of the word. And it would be my broad contention that it is over a period of time, the way the Constitution has treated minorities has changed. You can say it's evolved or it's gone back, but it's changed. Now, the first slide is basically a general understanding of how constitutions function. Now, the Constitution is usually, any constitution in the world is based on conventions and understandings. They are understandings which exist in society based on which constitution functions. And there are different methods of how you can change the constitution. Even written constitutions can be changed by unwritten rules, by judgments of courts, and unwritten constitutions by statutes. And two of the examples is number one, which everybody is aware of, the Marbury versus Madison, where judicial review was inserted into a constitution which was clearly written. And the second is the United Kingdom, where everybody knows that it's supposedly an unwritten constitution, though large parts of it is written at the present moment. When the European Charter was inserted into the constitution, and now the Supreme Court of the United Kingdom tests every statute which goes before it on the touchstone of the European Charter. Now, the broad thing is that you don't need to have specific amendments into the Constitution to change the Constitution. Politics changes the Constitution and the context, and the changes which are then reflected in the Constitution are reflected by the changing consensus which exists at that point of time. Now, next question is, why did I use the word avatar? Because avatar is a very Indian concept. It's not in the way which, it's used largely in the West. It's not a technical term. When we mean avatar, we mean, as we all know, is whenever there is, as the Gita famously says, that whenever there is, problems, trouble in the world, when Bharatvarsh is in trouble, I will come forth and I will redeem you. So God comes in various different forms and arises within us at various different ages. So for an age and a time, God takes human form and arises from within the society. So in many ways, my contention would be that the Constitution, though it has retained the flavor of how it treats religious minorities, has changed over a period of time without having any abrupt end. The essence has remained the same, but the form in which it has treated religious minorities has changed. So there are, in effect, different avatars which have happened. Now, I don't know whether anyone knows this, but if anyone has seen the 1935 Government of India Act, everyone would know that the 1950 Constitution which we have is greatly borrowed from the 1935 Government of India Act. In fact, people would tell you that they would be greatly surprised as to how much of the borrowing there is, considering, we all say that there was a clean break from, after the independence of India. The radical departure, according to me, and this is the first part which I'm going to submit, was the insertion of fundamental rights. Now, fundamental rights into this sort of a constitution was unique. It is not, again, I must, those who are aware, it is not that equality did not exist in the Constitution. Equality did, as a provision for non-discrimination in the 1935 Act. But what was the great radical departure was there were fundamental rights which were inserted, fundamental rights which could be implemented, fundamental rights which you could take to the court for violation. Balanced into these fundamental rights were the directive principles of state policy, which we all know, which were unimplementable. The reason why these were unimplementable is because, as everybody, all of us know who study the Constitution, is that DPSPs constituted a large volume of conflicting social values. And sometimes they conflicted with each other. There was that injunction against which we all know for the Uniform Civil Code. There was that injunction against cow slaughter. There was also injunction for distribution of wealth in society. So on various different issues, sometimes conflicting, but all these values which at that point of time, the vision was that these were to be the touchstone on which the performance of the government was supposed to be measured. But they were kept aside and not made implementable. Now, the contribution of Ambedkar into this fundamental rights chapter was quite immense, because he in many ways piloted this entire project. And he comes from as we all know, he comes from a very an American background for that matter. He had a doctorate from Columbia University in law. His first doctorate was from the London School of Economics in economics. So he does come from a very strong background in American law, and he piloted this fundamental rights chapter. And he thought it would revolutionize the entire concept of the Indian society. Now, his view, the large consensus at that point of time when the Constitution was formed, was that state was not going to be partial to any religion. And Ambedkar, when he spoke about it, said that social and economic organization is not the business of the Constitution. There's this very famous speech when Mr. K.T. Shah, who was a Constituent Assembly member, who was a socialist, tried to introduce a number of times the words secular and socialist into the Constitution. And every time, the Constituent Assembly 4 times rejected the word secular and socialist from the Constitution, rejected it per se. So when K.T. Shah actually comes to and proposes an amendment, Ambedkar gets up and he says that I do not want social and economic organizations to be inserted into the Constitution. Because he says these are values which you're inserting into the Constitution. And what is the value of a society changes. So I don't want to burden what I think is relevant today on the future society. So I don't want these values to be inserted into the Constitution. Now, what were the religious rights in the first Constitution? Now, Ambedkar himself again spoke quite about it. He said he was against, he said, why is religious minority protection important? Because as everybody knows, Ambedkar had conflicting views about rights of religious minorities. It's not, when we grew up, we were told that Ambedkar had a certain point of view, but as we grow older and we read, we realize that Ambedkar had quite a variety of views on how to deal with religious minorities. Ambedkar said that he was both against majority discrimination and minority perpetuation. He said to ensure that, majority did not discriminate, you had to have minority rights till the minority actually disappears. He foresaw a time when using these rights, the minority will not feel discriminated, and so the minority will not have a reason to exist. The group rights were given in Article 29 and 30 in the first Constitution, which provided additional protection to religious and linguistic minorities. Articles 25, 27, and 28 were individual rights, though Article 26, the right was given to religious denominations to maintain and manage their religious institutions. Religious and linguistic minorities in the first Constitution. Minority rights were read. Now, today the viewpoint of the Supreme Court is minority rights are an exception to the Constitution. As anyone who knows, who's Parth and we've all fought the right to education matter, the Rajasthan Society for Unaided Private Schools matter, we've seen the Supreme Court has said that actually minority protection in 29 and 30 is an exception to the other freedoms in the Constitution, especially even the right to education. Which has given right to wide-ranging freedom for minorities in running educational institutions, which has created this backlash of heartburn amongst the majority. However, and this is what I want to stress, however, in the original Constitution, the courts, once they came right after the formation of the Constitution, for a very long time, the courts chose not to expand the concept of minority rights, while accepting the uniqueness of minority protection. Now, as some of us may be aware, the Aziz Basha case of Aligarh Muslim University wanted to claim itself as a minority institution, and the court said very specifically at that point of time, you know, because the government grants have been used for the formation of the Aligarh Muslim University, it cannot be construed as a minority institution. Courts, in summarizing everything, courts were conservative and they did not stress on group identities. So for a large period of time, the courts were treating minority protection as largely individual rights protection. Now, what I like to call is the second avatar is the socialist model. In the 1970s, the Indian National Congress under Indira Gandhi moved to the left, both in terms of economics and in politics. There were two main opposition at that point of time, and it's important that we contextualize it. One was the Jan Sangh, which is the predecessor of the BJP today, and the other is the Swatantra Party, which every liberal in the room talks about. That could have been our alternative if the Swatantra Party existed. Now, Swatantra Party largely, they were both largely broadly of the same perspective, except Swatantra Party concentrated on economics and talked about individual rights, while the Jan Sangh spoke about religious issues. But broadly, their criticism, both as to the socialist model as well as the economics and the politics, were largely the same, though their stressing were different aspects. Now, Indira Gandhi decided to delegitimize both, and she brought in that famous amendment to the Constitution, making it socialist and secular into the preamble retrospectively. So thereby, you created a consensus on which you were going to be tested, and in one stone, you killed two birds with one stone, because you delegitimized Swatantra Party because you made it a socialist government, and you delegitimized Jan Sangh because you said you were secular. And there were large-scale amendments. There was the 38th Amendment, 39th, 40th, and very famously the 42nd. The 42nd effectively at that point of time made into a one-party state. And this coincided with the imposition of emergency at that point of time. Now this, again, this one-party state, creation of a one-party state wasn't a unique thing at that point of time, because Sheikh Mujibur Rahman had just a few days before that created such a one-party state in Bangladesh. So it was prevailing, and Sheikh Mujibur was quite close to Indira Gandhi. After all, she created Bangladesh, and Sheikh Mujib was quite in touch with her. Now, and this is it's not something which I'm talking, off the hat. Pranab Mukherjee, in his latest book, which he has published on the controversial years, says very specifically that people at that point of time when emergency was imposed actually conjectured that Indira Gandhi or the government of the day wanted to convert the state into a one-party rule, and it's one-party socialist rule like what Mujibur Rahman did. But that, as we all know, ended with the elections of 1977 when the Janata Party came to power, and this is the third avatar. Now, the Janata Party changed the autocratic amendments like the 42nd Amendment, but they were dominated by socialists. So all the autocratic amendments as to emergency, imposition of emergency, doing away with fundamental rights, making DPSPs overrule fundamental rights, they were done away with. But they left the values intact as they broadly agreed with the objects, but differed with the means. The exception is, of course, the right to property, which Parth is so fond of saying was taken away and put in as a constitutional right. And we had the discussion where the discussion was that, if we say that the socialist state in India was created in the second avatar by Indira Gandhi, then how do you talk about, what the Janata government did? Because the Janata government broadly were dominated by socialists, and they agreed with the goals of Indira Gandhi, though they said that yes, we differ only to the extent as to how they were to be implemented. So right to property was taken away because there was a lot of debate on the right to property, and it was put in as a constitutional right. What is the value of this constitutional right? That's still up to testing. Socialism and secularism, which were brought into the constitution by Indira Gandhi into the preamble, were not amended out. So they were kept. Now, from then onwards, socialism and secularism came to mean, in American terms, what is a dog whistle term, which used to be used for a certain kind of politics. So when you talked about socialism, you actually meant certain kind of issues. When you talked about secularism, you actually meant catering to group identities of religious minorities. That was quite clear. You talked about secularism where you talked about treating every religion as equal, but the whole intention was that you used it to consolidate certain kind of electorate for certain electoral purposes. Now, this consensus, the social democratic consensus, slowly broke apart because of these group identities started being highlighted. Now, the rise of group identities. Now, we all know what happened in the 80s. The Shah Bano judgment and the Ram Janmabhoomi movement came right beside each other. Once you start concentrating on group identities, this was the result. Now, this entire move towards group identities finally ended with, sort of culminated in the Mandal Commission report, which we all know, where the Supreme Court, in final, once the Mandal Commission was introduced, which said that different castes should have a representation in government broadly. That was, the Supreme Court addressed it by saying caste is class. And it also said in that famous judgment of Indra Sawhney, which we all know, is that merit is not the only criteria for placement, for reservation, for benefits from the state. So once you take that stand, your entire liberal consensus, which you started off the first constitution with, you actually threw it out of the window, because that is where it ended. When the Supreme Court came to the conclusion that caste is class, so there is no economic criteria, but economic criteria and social criteria is the same thing, and so that could be the basis of discrimination. And also that merit cannot be the only criteria for improvement in one's life, and so there should be a social criteria as well. So that basically put the finality as to this debate. From then onwards, there were competitive demands of groups on national resources. Now, this was coupled with the collapse of the state and the socialist regime, and coming of the market and the expansion of the private sector, which made it even more important for these groups to demand educational reservations, to demand reservations in public jobs. This is then the fourth avatar, which I talk about, is the consensus model of constitutionalism. Now, this is a theory by Lichfart, who is, in his book on patterns of democracy, discusses various different countries like Switzerland, Lebanon, Belgium, etc. And he talks about what is called the consensus model of constitutionalism, where different groups share power based on their identities. As we all know, in Lebanon, the Shias, the Sunnis, and the Christians share power amongst themselves in a constitutional formula. Similarly, people speaking linguistic groups share power in Belgium, in Switzerland, share power based on a certain formula, a constitutional formula. He says this is a model which is followed in different countries. Effectively, what happened in the 90s is polity and politics in India came to be organized on group identities. Like, I use Indian words deliberately because they're unique and it has its own connotation. On jati, that is roughly translated as caste, on bhasha, which is roughly translated as language, and dharma, which is roughly translated as religion. More jati and dharma. It became more on jati, on caste and religion. They were the two original centripetal and centrifugal forces in Indian politics. And there was an attempt at some point of time to make out as if caste and religion were the same thing, jati is equal to dharma, so religious minorities were castes in themselves. But I don't know how much, but that is in itself very controversial, even amongst religious minority groups, as to whether they are a caste in themselves or whether there are various castes within religious minority groups. I'm sure you're all aware of the Pasmanda debate, whereby other backward caste Muslims who have asserted themselves against Ashraf and Ajlaf. So that's another topic which will detract from. Now, again, the culmination of this entire debate was when the Prime Minister said in a speech, the Prime Minister at that point of time, Manmohan Singh, said in a very famous speech that religious minorities had first claim on nation's resources. This consolidation on religious groups was not on historical reasons but on relative discrimination. Ranganath Mishra and Sachar Commission justify the policy of discrimination, unlike backward classes. So they first decided on that they wanted to discriminate, and then they came up with the Ranganath Mishra and the Sachar Commission. Net result today, what has now happened is dominant social groups are demanding reservations. You know, the entire Patel reservation. And also what is surprising is that liberal voices, get smothered. What happens as a result? Liberal voices within religious communities, religious minority communities get smothered because the unity of the group becomes very important, because it is the unity of the group which can get concessions out of the state. Now, 2014, this would be my view, with sort of individual empowerment and financial individual empowerment being the basis of the ideology of the present government, I perceive that maybe there may be a return to individual rights again and away from group identities. But this would automatically create a lot of a backlash within the groups, because there may be an outrage because the original power elites of these groups may be losing power. Last, I think, consensus model doesn't work, so two choices, either the new interpretation or an old interpretation, go back to individual rights. Now, the present thinking in constitutional law is that there is a lot of tradition being read into constitutions. So there's not only liberalism, modernism, but people are reading their old traditions and ideas of society back into the constitution making. In many ways, now it's almost the end of modernism as an ideology. What I foresee in the future, minority rights will be the site of clashes in the future. But there is great value of modernism, because modernism taught us two very important things. It taught us individual freedom and protection of religious minorities are universal values. These are things which we have to take lessons from modernism. And after all, a society is known how it treats its religious dissenters. That's been a hallmark of a good society, a tolerant society, a virtuous society. And I think the ideal Indian state would be what, the Mauryan state as sort of signified by Ashoka, which was deeply rooted to civilizational values, but also very conscious of protection of religious minorities. Thank you very much.